Hello and welcome to today's Foreys webinar. Thank you for participating in our discussion today on foreclosures and receiverships. Before I begin, I want to cover a few housekeeping items. At the bottom of your screen are multiple application widgets you can use. All of the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. If you have any questions during the webinar, you can submit them through the private Q&A widget without disturbance to the program. If you are having technical issues, you can find answers to common technical troubles located in the Help widget at the bottom of your screen, or you may submit a question via the Q&A widget. An on-demand version of the webinar will be available approximately 1 hour after the program has concluded and can be accessed using the same audience link that was sent to you earlier. Finally, as a reminder, this webinar is for general information purposes only and should not be regarded as legal advice. As always, you should contact your Foreys attorney if you would like more information or have questions about how these developments apply to your situation. Now, for opening remarks, I would like to turn the call over to Brian Farkas.
Good afternoon, everybody, and thank you for joining us for our fourth annual commercial loan workout webinar series. Today, we will be covering foreclosures, both for real property and personal property, and also receiverships, both federal and state. I am Brian Farkas. I am a partner in the Cleveland office, and I'm joined by my partner, Carrie Brocious, who's also in our Cleveland office. So I will start with foreclosures, first covering real property foreclosures, then we'll get into personal property, and then Carrie Brocious will be handling the second part of the presentation, which will cover receiverships. With real property foreclosures, a lot of times when people think of foreclosures, they think of, a very dry, kind of hyper-technical process, which parts of it are. But what I'm hoping, one of the main messages you'll get from today's webinar is that to think of foreclosures in a very strategic manner, like any process, at different points there's opportunities to make decisions which have major ramifications upon the results you're going to obtain from liquidating your collateral. So as an initial matter, even before you file any type of foreclosure, whether it's on your real or personal property, as you'll see on our first slide here, one of the first things we ask our banks to do, our lenders to do, is to think about, is there a quicker, more efficient way to get to the end result rather than filing an actual court action or doing some sort of legal proceeding to sell the collateral? Is there some way to do either a structured workout or a deed in lieu of foreclosure? The concept in a structured workout would be something to the effect of, speaking to the borrower about getting a substitute lender to take the bank out, or some sort of sale process that the borrower and guarantors, for some period, 3 or 6 months, endeavor under a forbearance agreement to sell the property through normal marketing channels, which may garner a greater net result for the bank than filing a foreclosure. A deed in lieu of foreclosure is also a very useful tool. Instead of filing a foreclosure, as we'll see later in the foreclosure process, foreclosures normally take quite a while to complete, in Ohio especially. So if you can work out an agreement by which the borrower and the guarantors agree to deed the property over to the bank, and then the bank will sell the property on its own, that can normally be, that transaction, we can normally consummate that within weeks, maybe 30 days, as opposed to an elongated, legal foreclosure process. Now, in thinking of doing the deed and foreclosure route, that route can only be done if once you've received, the first thing you want to do in considering the deed in lieu options, you want to get title work. You need to make sure there are no subordinate lien holders, because if there are subordinate lien holders, obviously you don't want to take a deed to a property in which there are other lien holders on, Sometimes we're able to negotiate those liens off because those parties understand if the bank files a foreclosure, they're just going to get wiped out anyways. But you need to review and have your counsel review title work to see if a deed in lieu is even feasible. The other thing you need to do is you just need to do some basic due diligence on the property. A lot of our lenders obviously have REO departments that can do this, but getting an environmental, getting a survey, making sure this is a property that isn't coming to you with any hair that you're not anticipating, so that as you are in the chain of title, you're not getting yourselves into any liabilities or problems. A couple other things to note if you are going to go in the deed in lieu of foreclosure route is to make sure that you're able to stipulate in the document that the value of the property is not in excess of your debt. The issue there being is if the property is worth, some amount material above what the bank is owed, other creditors of the borrower can come and later claim that somehow this was a fraudulent transaction. The bank got more than it was entitled to, and it got a windfall. So that issue I have not seen be an issue to block the deed in lieu, because obviously if there is more value there, the borrower is going to want to get any excess. So normally this is not an issue. Finally, one of the big things with a deed in lieu is you want to make sure that you don't release your mortgage, even if you record the deed, because if somehow this transaction is attacked as a fraudulent transfer, and somehow the deed that transaction is undone because our borrower files for bankruptcy or something happens after the deed in lieu transaction, you'll still have your mortgage there as protection, and you can still foreclose at a later time. And then lastly, and this is on every document the bank ever signs with one of its borrowers, is you want to make sure you get a release somewhere in that document of claims. You don't want to do a deed in lieu with your borrower to all of a sudden then be fighting with your borrower about some sort of lender liability claim that they want to bring against the bank. Now, if you decide can't do a deed in lieu, can't do any type of forbearance, we do need to foreclose after the borrower has breached under the loan documents. Again, there are strategic considerations for both the lender and the lender's counsel to go through and discuss prior to filing and during preparing the complaint for filing in a foreclosure. The first one is what county you're going to file in. Generally, that's going to be wherever that property is located, but there could be some other factors that determine which county you're filing in. If there are multiple properties in multiple counties, you can choose just one of those counties. If there are guarantors living in other counties, you can find a way into a more beneficial forum that you may have less issues, and the timing and the speed of that county could be more advantageous for the bank in getting to a quick foreclosure sale. And so thinking about which county you're filing in, if you have options, speaking with your counsel about which county to file in is a strategic decision. You're obviously going to need title work, either a commitment or a preliminary judicial report. Again, thinking strategically of where you're going to be filing, not only which county are you filing in, but do those counties have a commercial docket? Generally, commercial dockets are a better place for a lender to be. There's a multitude of reasons for that, but the most important one is that they're generally going to be the most efficient, and if the borrower is bringing up very tenuous claims, they'll get dismissed very quickly. The next item is, what do you do with leasehold interests when you're foreclosing on a piece of commercial property? 9 times out of 10, all the leases are subordinate to the mortgage, so it's not necessarily an issue of whether you need to name them as a defendant or not for that. They're going to be foreclosed. But a lot of times, for strategic reasons, you may or may not want to name the lessees in the complaint. You have every right to. I have had situations where I have specifically named all the tenants in the foreclosure complaint because we plan to get a receiver. And the message we wanted to send to the tenants was that there's a foreclosure on this property. Basically, do not send your rent payments to the current owner. We're right about to take over via a receiver. So it's messaging and signaling, and if there's substantial rents on a property, but the length of time between filing your foreclosure complaint and getting a receiver could be 30, 60, maybe even 90 days. Those months, if you can find a way to signal to the tenants to hold on to their rent checks, that is rent that could be very valuable for the bank and the receivership, and not going into the back pocket of your borrower. The length of time to complete a foreclosure sale, if it's uncontested, generally we're thinking of 6 to 8 months. Some counties it could be as long as 10 to 12. And so again, that's something to think about strategically, about the length of time it's going to take and the energy expending, even in an uncontested foreclosure. If you're dealing with a contested foreclosure, obviously, depending on the strength of your borrower's claims, it can really extend the length of time. So again, thinking about whether you want to file the foreclosure or do a deed in lieu or some other workout option, I think that length of time is a major issue or a major factor in considering which option to go. And then when you file your complaint for foreclosure, do you want to seek the appointment of a receiver? Carrie's going to get into much detail on that, but generally, for commercial properties that are rent generating or need maintenance, you're probably at the very least going to want to consider appointing one. Once you've decided and you have filed your complaint, these are kind of the general steps of the foreclosure process. Every complaint you need to obtain lawful service on each of the defendants, and generally that's done by certified mail, signed receipt, which has become a little bit of an issue with COVID and post-COVID. We have received a lot of failure of services due to the fact that the excuse that is being given, whether it's legitimate or not, is that because of COVID, no signature was obtained. There's actually a split of authority in Ohio of whether that's good service. Since it can be an issue, what we've been doing is getting process servers to hand deliver these things, and that is a good form of service, and it avoids the issue of delaying the foreclosure process by not getting good service. Once you've gotten good service on the defendant in Ohio, they have 28 days to respond. Once they've responded to the complaint, if there's no legitimate defenses in their answer, or they have not filed an answer at all, you'll be able to file a motion for default judgment or summary judgment. In one practice note that I want to stress to our lenders is that with these motions, a lot of times we will ask you to sign an affidavit stipulating to the amount of the principal, interest, fees, etc. Please make sure that you review those affidavits very carefully. It is sworn testimony, and you could be called by the court to actually testify in person on those issues. So we need to make sure we're carefully reviewing those documents and making sure we're not making any mistakes with interest, etc., and fees. And then finally, once you've filed your dispositive motion, the judge will rule on it and will give you your foreclosure decree, so long as there are no legitimate defenses being raised by the borrowers. That foreclosure decree will give you the power then to set the property for foreclosure sale. And there are 3 ways that you can go about selling a property through the court process. These three ways are the traditional sheriff's route. Every county has a sheriff, and they do have a foreclosure department that will go through all the steps to sell your collateral. The other two possibilities are a private selling officer, which is basically a broker being appointed by the court to sell it, or a receiver sale. So let's go through each of these. The first, which people are probably most familiar with, is a sheriff's sale. The sheriff's office will send out at the beginning of the process, we'll send out 3 disinterested appraisers to do a drive-by appraisal of the property to set the value of the property. One thing to note is that these appraisers, when they appraise the property, they simply do a drive-by. I mean, it is not a sophisticated appraisal. It is not an internal inspection. They're not. It is a very it is a very perfunctory process. So that's something to note as far as understanding when the sheriff's doing the sale, what type of appraisal you're getting. The next thing they do is once they get the value, they will set a sale date, and they are required by law to advertise the sale date and the appraised value of the property for 3 consecutive weeks in a local publication in that county. Generally, the advertising is not the most prolific. It's in an innocuous journal or paper at the back, and it's the minimum amount of notice required. And I don't think it really even can be considered marketing. It's simply giving notice to the public of there is going to be a sale of this property. Once that advertisement goes out, the bank, the lenders are required to send out a notice of sale to all the parties in the case as to the date of the sale. At the sale itself, a lot of courts now have remote bidding. As a practice note, it's important to note that the property by law needs to sell for a minimum of 2/3 of the appraised value. So keep that in mind as far as what is going to be required at the time of the sale, and whether or not you want to credit bid at the property at the time of the sale. Again, I would use the same process that you use in a deed in lieu process as far as whether this is a property that you want to take title to. Once the sale is completed, the sheriff will return that paperwork to the judge, and it'll be confirmed that the sale was done according to law. And finally, the sheriff will record the deed. The other two ways that you can do a foreclosure sale is you can, under Ohio law now, have a PSO, a private selling officer, which is basically a broker, and that broker will be empowered to do what the sheriff does, but also be able to do traditional marketing for whatever type of property you're trying to sell. I think most people believe this is a much more preferred option over the sheriff sale. It can be done for commercial properties, residential properties, and especially in the residential context, there's a whole market of brokers that are willing to do these. It'll get on the MLS listing, and really the only downside that I can see on this is that you're going to have to pay the extra broker commission, but it's well worth it for the marketing that you're able to get. And unless the property has an issue, that going through a sheriff's sale makes more sense. In 9 times out of 10, I think a PSO is the way to go. If you have a commercial property, and this last possibility of doing a receiver sale, maybe even better than doing it through a PSO, is because during the time you file your complaint until you get your order of sale, the receiver can collect rents, can actively manage the property, can be your eyes and ears at the property, where a PSO is simply just going to market and sell, a receiver really comes in to manage the property and maintain it. So for commercial properties that need that type of an attention, the receiver route is probably even going to be more preferable than the PSL. One thing to be just note is that when you get a receiver appointed, there is going to be additional court process. There's going to be some more hearings, and there's going to be additional expense to pay the receiver and to probably pay some receiver attorney fees. And the last thing I'll just say about receiver sales is, depending which county you're in, this is going to be something you're going to want to discuss with your counsel about the chances and probability of you getting a competent receiver. In different courts, we've had different levels of success in getting a qualified real estate receiver to do the marketing, to do the maintenance, and to do the management. So again, at this point in the process, if you're considering a receiver, again, I think it should be thoughtfully done as a strategic decision to make sure you understand what you're getting yourself and the lender into. Now, switching to personal property, if you need to foreclose on any personal property, there's two methods to use to reduce your collateral to cash. One is just the traditional filing a court action and asking the court to allow you to repossess your collateral and or just sell it via sheriff's process. Most of the time when we file these actions in court to get access to the collateral and to sell it, we will get a receiver appointed because we want somebody in there that's going to do some strong marketing of the equipment, of inventory, etc. So at the filing a foreclosure action on personal property is going to be necessary. Step one is going to be necessary if you're going to have to file some court pleadings, even if you do an Article 9 sale, in the event that your borrower is not cooperating or you have a landlord that's not giving you access to your collateral. So sometimes you even have to institute a court action simply to repossess your collateral. But if you're going to be filing a court action to repossess your collateral, a lot of times it makes sense to also ask for a receiver at that time and then just do the sale process through that receiver. If you can repossess your collateral, either voluntary or you have already repossessed your collateral, a lot of banks, for efficiency purposes, like to do an Article 9 sale. Article 9 of the, I'm sure most of you have heard of it, but just to refresh everybody, Article 9 of the revised code allows a lender the right after a default to go through a process to sell and liquidate its collateral. There's notice requirements. Every aspect of the sale needs to be commercially reasonable, and there's some options as far as whether you do the sale either through a public auction process or a private sale. Now, the notice requirements basically require you as the lender to send out a form notice to a group of parties that talks about a few things. But let's just talk about who you need to send this notice of sale to. You need to send it to your borrower. You need to send it to any guarantors. You need to send it to any secured parties of record. So that means you're going to need to do a Secretary of State search. You're going to need to do some due diligence to make sure you are aware of all of the other secured parties out there so they get notice of this sale as well. The notice, what it needs to contain, it just needs to contain the name of who your borrower is, who you are as the lender conducting this Article 9 sale, what personal property is going to be sold, how will it be sold, will it be a public auction, will it be a bidding process, will it be done privately, and the time and the place of the sale. As far as the big question we always get is how much time before the sale do we need to send out this notice of sale? Well, Article 9 provides that as long as you provide this notice to all the parties at least 10 days prior to the sale date, that's to be fine, and that'll be acceptable as commercially reasonable. And then the last thing I wanted to go over is what public or private. 9 times out of 10, we do a public sale just because we don't want any other secured parties or the borrower later bringing up claims that we didn't maximize the value of the collateral. And so when you do a public sale, obviously it's much easier to just provide evidence that you took this to the market, you allowed everybody who wanted to bid on this to bid on it, and this was the best price you could get. Where obviously, if you do a private sale, it can be harder just to make that proof, and so public sales are generally the more preferred. So finally, what would be some of the pros and cons of doing a foreclosure in a court action proceeding or doing an Article 9 sale? Well, in a court action, there's obviously increased costs because you have to pay counsel to go through the process of filing the pleadings, etc. You might have to go to a hearing or two as well, but there's less exposure to any second guessing after the sale because you're going to get a final court order that says the bank is permitted to sell the collateral at such and such date for such amount, and all the parties, this presumes obviously that you've served all the parties that you needed to, all the parties to the case are going to be barred from ever second guessing the court after the final order has been entered. So you're going to have certainty once that court action is completed and your collateral is sold, that you're not going to have any liabilities or potential claims later by any of the parties because you have that final court order, and that's going to be kind of a shield to any of those claims. Contrast that with an Article 9 sale. It's more efficient generally. It's a pretty seamless process, and you just follow the steps that we discussed. You send out your notices, you do your public sale, etc. However, there's never a final court order at the end blessing whatever you did. So there is some increased potential liability that, a third-party creditor, a guarantor, if you try to collect on the deficiency, may try to bring up claims of that some part of the sale was not done in a commercially reasonable fashion, and you might have to fight that battle in court if they bring up those claims. So with that, I am going to turn it over to Carrie Brocious, who is going to cover receiverships.
Thank you, Brian. Like Brian has already mentioned, receiverships can be a great alternative to going through a foreclosure process. Oftentimes, the receiver is going to be able to do it more efficiently, faster, and he or she's going to be able to yield a better result for you when it comes to liquidating your collateral. Now, what exactly is a receiver? A receiver is a court-appointed officer of the court. So the receiver is not there for the creditor. The receiver is there for the court, and the receiver is going to look after not only the creditor's interest, but the junior creditor interest and the borrower's interest to make sure that everybody's interests are in play. More often than not, in practice, the receiver is catering to the creditor because the creditor is the secured creditor. There has been a default. The secured creditor has rights and remedies that he's entitled to exercise. And more often than not, the receiver is undersecured. So sometimes it does appear that the receiver is in place there for the creditor. The statutory provisions that pertain to whether or not a receiver can be appointed and the authority that that receiver may have really varies among the jurisdictions. And we're going to get into that a little bit later on. One thing to keep in mind, always with a receiver, is no matter what court you're sitting in, whether it's federal or state, or in any state, your appointment order is typically going to control the scope of the receivership and the authority that the receiver has. So when you are planning your receivership, you really want to think out, what do I want that receiver to do? And you want to make an effort to make sure that that is included in the appointment order. Now, what is, excuse me, I think sorry about that. Now, what's the purpose of a receivership? Why do typically people seek to have a receiver appointed? Oftentimes, a receiver is appointed to preserve the debtor's assets for the benefit of the creditors, to conduct a foreclosure sale of some sort, if you will. Sometimes a receiver is appointed to prevent the debtor's waste or mismanagement of the assets. Sometimes a receiver is sought because there is an indication that some fraud is going on. There's a number of reasons why a creditor may seek out the appointment of a receiver. Most of them pertain to mismanagement, fraud, or just the ability to exercise rights and remedies in an efficient manner. How is a receiver appointed? Well, typically the lender will file a complaint for breach of contract or for judgment on the note, and that complaint will be accompanied by a motion to appoint a receiver and a proposed order. Most often, a debtor is provided an opportunity to respond to the motion to appoint a receiver and to have an opportunity to argue why a receiver should or should not be appointed. There are some instances when a lender can have a receiver appointed ex parte. And by ex parte, I mean without giving the other side an opportunity to object or to be heard. This only is going to occur in very limited circumstances. This is going to be in instances where you have very mobile collateral that is able to move out of the jurisdiction easily, and there is cause to believe that the debtor is going to try to hide the assets or run away with the assets, if you will. In those instances, a creditor can go in and say, hey, my borrower is a trucking company. My collateral, is basically all these semis and semi-trailers, which can be moved all across the country. And once this gets out, I will have no idea where to go look for them. Please, 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 appoint a receiver ex parte. In instances like that, a court may allow a receiver to be appointed without the other side having an opportunity to be heard. Another instance where I've had a receiver appointed ex parte was with a real estate. I had some low-income housing projects that the borrower and manager decided overnight, 4 days before Christmas, that they did not have the money to pay the insurance premium, and they were sick of operating it and didn't have the means to go forward, and they provided the bank notice that they were just no longer going to manage the company or the low-income housing projects. And these were houses throughout the eastern side of Cleveland in the middle of winter, where there were continual maintenance problems, pipe issues that needed to be addressed for the tenants immediately, or the tenants would be put out, or the collateral would suffer harm. We also had some vacant properties where you had some concern of vandalism if the properties weren't properly maintained and watched over, or again, with it being winter in Cleveland, the pipes breaking. We went in with a complaint and a motion on December 23rd, and by the end of the day, we had a receiver in place, up and running, bond posted, and he was able to seamlessly, pick up those properties. And the bank was not in a position where they suffered a loss for their collateral. The tenants weren't in a position where they were running into the holidays, and if they were faced with a maintenance issue, who were they going to call? One thing to keep in mind, in most instances when you do get a receiver appointed ex parte, more often than not, like in the trucking example I gave, the court will appoint a receiver on an interim basis. So if the receiver can go in, get control of the collateral, lock things down, maintain status quo, then give the debtor an opportunity to respond. So just keep that in mind. You might win on day one, but it's only for a limited period of time. Once the judge grants the appointment order, you're off to the races. And I've already given some indication as to what would a judge find, what factors a judge would justify appointing a receiver. You have the fraud, you have the risk of the property being lost or stolen, you have, mismanagement, and then you have a contractual right, which I haven't touched upon. Often, actually almost always, your credit agreements, your security agreements, your mortgages will include the remedy to have a receiver appointed. That makes having a receiver appointed is now a contractual right for the creditor. Oftentimes, that language will go a step further and say that the creditor has the right to have a receiver appointed upon the occurrence of an event of default, irrespective of the value of the collateral in comparison to the debt. And then that language can go even further to what I call the Cadillac receivership provision, where it will say, and if an event of default occurs, the borrower hereby consents to the appointment of a receiver. Now, depending on what state you're in the applicable statutes, that consent language can almost mean a slam dunk to having a receiver appointed. It's a contractual right. You've already bargained for it up front. You have an event default, you are going to get a receiver. Now, there are different types of receivers. Brian has already kind of alluded to this. There are receivers that come in and they're appointed strictly to liquidate the assets. They're going to run a glorified Article 9 sale for you. Other receivers are going to come in and they're going to operate the business as a going concern. They're going to assess the financial condition of the business, and maybe they'll sell the business as a going concern, or maybe later on they'll make the determination that, liquidating the business in parts and pieces is the best way to go. Other times, especially when there's been mismanagement, sometimes the receiver will go in, conduct some forensic accounting, and then the parties will decide the best way forward. We also have what we call our real estate receivers. These receivers go in and they're strictly dealing with receivership. There's no corporation making widgets and collecting ARs. They're strictly taking control of the property, collecting the rents, maintaining the properties, and then in most instances, they are also going to take on the responsibility of marketing and selling the property. Again, I said this before, but it's really important to understand that your appointment order really is going to control the scope of the receivership and the receiver's authority. You're going to find that most state statutes are pretty skimpy on what a receiver can or cannot do. So you're going to be falling back on that appointment order. So when you're contemplating a receiver, it really is worth your time to put more effort and thought into that appointment order. Now, there's no exact form for an appointment order, but there are provisions that you typically will see in most, if not all, of receivership orders. First and foremost, usually up front, you have the order provides that the receiver can take immediate possession and exclusive control over the assets, and it's going to define what is in that estate's assets. Is it just real property? Is it real property and equipment? Is it real property, equipment, and a business as a going concern? It's going to define what the receivership estate is and what the receiver has control over. And again, this is another area where you want to give some thought to make sure that every little piece of your borrower's operations or every little piece of collateral that you want that receiver to liquidate for you is somehow recognized in that appointment order. And the appointment order may indicate whether or not the receiver can manage the business property and operations. Sometimes the receivership order is going to cover whether or not the receiver can collect, sell, liquidate, and dispose of real and personal property. Oftentimes, the receivership will provide that the receiver can sell assets in the ordinary course of business. So if he's operating a widget factory, he can continue to sell the widgets as they're produced. If you're following the slides, you'll notice that I have an asterisk next to real property. States vary on whether or not they permit a receiver to sell real property free and clear of liens. 20 years ago, 15 years ago, this wasn't even a settled case law here in Ohio. Some counties would allow you to sell property free and clear of liens, some counties wouldn't. Ohio, fortunately, did an overhaul of the receivership statute about 10 years ago, and they clarified that a receiver does, in fact, have the authority to sell real property free and clear of liens, and it set up a procedure to do so. Appointment orders are going to allow a receiver typically to enter into and terminate contracts. There's going to be language in there that's going to prohibit third parties from engaging in self-help or otherwise interfering with the receivership. And again, you're going to notice another asterisk here. This prohibiting language in the receivership order really only goes so far. It is going to prohibit third parties from coming in and scooping up receivership assets or trying to collect receivership assets. What it's not going to do is it's not going to prevent your vendors from terminating contracts, your vendors from refusing to supply you. It's not going to prohibit your customers that you have an agreement with terminating the contracts and walking away. Receiverships have a lot of benefits, but they don't quite go as far as a bankruptcy filing and the benefits you get from the automatic stay under the bankruptcy code. Getting back to an appointment order, oftentimes that order will include the ability to hire and terminate employees. It will cover reporting obligations that the receiver has to the parties and the courts. It will have the authority to retain professionals. This is, counsel and accountants to help aid the receiver. Sometimes it will even cover, the receiver's ability to retain a broker. The receiver is going to be able to intercept mail, open bank accounts. It's going to specify whether a bond is required and how much. Oftentimes, you can get a receiver appointed without a bond, but it's going to vary. Sometimes you'll have a contractual right to have a receiver appointed without a bond. Other times, it's going to be up to the judge. And again, going to the power to sell. If you are in a jurisdiction that allows a receiver to sell real property, or if you're just looking to sell personal property, sometimes that appointment order is going to cover the power to sell in detail, particularly if you're dealing with selling a business as a going concern or you're selling real property. Sometimes your appointment order will look like a mesh between an appointment order and what you would see in a 363 sale order in a bankruptcy case. It's going to lay out how the receiver is going to market the property, if he's going to do it in an auction, or if he's just going to, vet bids here and there. If he's going to conduct an auction, how is it going to be conducted? How's he, when's the deadline? Is there going to be a run-up bidder? The whole 9 yards. More often than not, if you are going to have a sale process that complicated, you will see a separate sale order. But you also can see it in the appointment order. It really depends on what the creditors would like up front, and it also depends on what are the assets that make up part of the receivership estate. Now, once appointed, what do receivers do? Upon appointment, one of the first things the receivers are going to do is they're going to go in and they're going to take possession of the assets and control the business operations. They're going to inspect and inventory the assets. They're going to assess the business operations and the financial condition, and they may conduct an examination to determine if past fraud has occurred. From there, they're going to decide the best way forward. Maybe it's starting up the liquidation process. Maybe it's to operate the company a little bit longer to kind of right size the books so that it's a little bit more appealing on the market. I mean, basically, a receiver is going to come in and they're going to manage and operate that estate. One thing to keep in mind when you're contemplating whether or not you want to go a foreclosure route or an Article 9 sale route or have a receiver appointed, there are fees and costs associated with the receivership. Receiverships can be expensive. You have to pay the cost of the receiver, his professionals. If the receiver is going to be operating real estate or he's going to be operating a business as a going concern, those operation expenses need to be covered. Even if you have a receiver appointed simply to take control of the assets and sell them off, you're going to have insurance costs. You're going to have sale costs. You're going to have storage fees. So you want to factor all that in. And I will caution you, trying to estimate the cost of a receivership upfront can be really difficult, particularly if you are in a jurisdiction where it's kind of unknown who your receiver is going to be. When you're determining whether or not to appoint a receiver, you often are going out and you're going to look for who can be my receiver. And you're going to find someone who is known to be efficient, who knows how to operate the type of business that is subject to the receivership estate, or knows how to liquidate the particular type of collateral you have. And you base it upon what that person's rate is, what they typically, find their receiverships to cost. And then you get into court and you ask the court to appoint a receiver, and the court says, you know what, you are entitled to a receiver. However, I'm not going to appoint this particular person. I don't have to. I'm going to appoint this person instead. And now you may be stuck with somebody who is twice the cost. They don't know what they're doing. They really drag things out, and sometimes the cost of the receiverships will double or jump up significantly. I can recall one receivership where we carefully selected someone to serve as a receiver. We were in one of those jurisdictions where oftentimes the receiver is looking to return favors, and they do that by appointing other individuals as receivers. And instead of getting someone who could knowingly and efficiently run that receivership, we had someone who was double the cost and didn't know what they were doing. And ultimately, after wasting 6 months, they turn around and hired the person that we recommended as a consultant, to add insult to injury. So then you had double the cost. You paid for the receiver, you paid for the consultant, and you had this huge time lag, and it just dragged out. It turned out to be just a complete bloodbath. So keep in mind, there are risks associated with receiverships. The level of risk you have is going to vary based upon what jurisdiction you're in. So you really want to talk to your counsel about what can I expect from the court that I'm filing in. If I don't know what to expect, if it's one of those ones where I might get who I asked for, but I might not, just factor in, you might not be able to really anticipate the cost and fees of this receivership. And it's important to consider that, because generally the fees and the cost of a receivership are paid from the proceeds of the collateral or from the business operations. But if that receivership becomes insolvent, more often than not, the courts look to the party that sought the appointment of the receiver to pay the difference. So it could, not only would you not be realizing what you had hoped to realize on your collateral, but now you might be coming out of pocket to pay for the receiver. Now, when it comes to appointing a receiver, you can have a receiver appointed in federal or state court. Federal receivers are nice in the fact that they can exercise authority in multiple states. State court receivers have limited authority. Their authority pretty much stops at the state line, but you often are dealing with judges that are more familiar with the receivership process. Now, when it comes to federal receiverships, some of the benefits, in addition to reaching out to states outside of the jurisdiction that you're sitting in, is the federal receivership law is more comprehensive than most state law. The federal laws give the receivers clear authority to sell collateral. Particularly, they give clear authority to sell real property, and they outline procedures for how a receiver would go about selling property free and clear of liens through either a private sale or through a public sale. One of the fallbacks to a federal receivership is, or one of the things that makes a federal receivership hard to obtain is, in order to get a federal receiver, you have to have federal jurisdiction, meaning you have to have, the federal court needs to have jurisdiction over the complaint you're filing. And in a creditor-debtor relationship, oftentimes the only way you're going to have that occur is if there's more than $75,000 at stake and there is complete diversity among the parties, meaning if you're an Ohio bank, your debtor needs to be a business organized in Kentucky. Or if you're a national association and you're based in Pennsylvania, your borrower cannot be sitting in Pennsylvania. It cannot be organized pursuant to the laws of Pennsylvania. The other disadvantage to federal receiverships is federal judges typically are not used to receiverships. So you can spend a little bit more time and effort than you would in a state court educating a judge, getting a judge comfortable with the relief that you're seeking and with the authority that you are hoping that your receiver will exercise. But the big advantage is, and a federal receivership is great if you have collateral in multiple states, is that federal receiver, his authority goes beyond the state line. It goes beyond the district line. There's a process in the federal code that simply says that the receiver needs to file a copy of the complaint and his appointment order in whatever districts where the collateral or the property is located, and immediately he will have authority. It's a very simple process. When it comes to appointing a federal receiver, you might be worried, well, are the qualifications or requirements higher than what you would have at the state level? In fact, they're not. Basically, the receiver cannot be a clerk of court, the receiver cannot be employed by or related to a judge, and a receiver cannot be a federal employee. Plus, the receiver must be disinterested. If you can meet all those qualifications, you can be a federal receiver. Federal receiver powers, the statute outlines certain authority that the receiver has, but once again, when you're in the federal setting, the appointment order is going to be key, and whatever authority you want that receiver to have, you should make sure that it's included in the appointment order. Now, there's a limit on the powers that a receiver has, and this applies not only for federal receivers, but state court receivers. A receiver must act within the scope of the authority granted to them by the statute or by the appointment order. And this is important not only to the receiver, but to the creditor who's relying upon the receiver to sell. If the receiver acts outside of his authority when it comes to conducting a sale, not only does that receiver, him or herself, faces possible sanctions, but you are looking at possibly having a sale avoided, having a sale unwound, meaning creditor, you're not getting your cash back, and buyer, you may not be getting what you thought you were buying in the first place. So you really want to take care, particularly in a sale setting, that your receiver is not overreaching. And this is true not only at the federal level, but at the state level. Now, state court receivers, the rules vary greatly from state to state. And the rules are going to cover the appointment process, the powers of the receiver, and the grounds in which a receiver may be appointed. Most state statutes are pretty skimpy. What you find in the states where the statute's kind of skimpy isn't a limitation on the receivership, but you will find a hodgepodge of case law out there that says what a receiver can and cannot do, and you can find some contradicting rules among the statutes, and so there might not be any real clarity about what your receiver can or cannot do. Again, just further giving examples of how state laws vary. The state laws are going to vary on, the justification for appointing the receiver, the justification for having a receiver appointed ex parte. They're going to vary on the enforceability of the contract provisions. There are some states where even if you have a contractual right to have a receiver appointed, it's not a foregone conclusion that one will be appointed. And the state laws really vary with respect to the stays against creditor actions. This is going back to the discussion that we had earlier about whether or not your appointment order can stop a third party who's not a part of your action from doing or not from doing something, from exercising their own rights and remedies, or from just terminating their own business relationships with the business that is in the receivership. And where the receivers do have permission to sell real estate, often it's not clear if that sale is free and clear of liens. So when it comes to having a receiver appointed at a state court level, you really need to work with your individual attorneys to find out what is or is not permitted in that state. If you're in a state where it's kind of the Wild West and there's no rules, you have to, think about what county am I sitting in and what risks do I face? In an effort to try to bring uniformity among the states, the same organization that came up with the UCC has published a uniform receivership code. It's kind of modeled after the federal rules. It hasn't really taken off yet, but it's out there in the hopes that someday receivership law will look a lot like Article 9 or Article 2 law. I apologize. For some reason, the slides don't want to advance for me on my first click. Just really briefly to summarize, what are the pros and cons of federal and state court receiverships? With federal receivers, the downside is you must have federal jurisdiction. The judges may not be as familiar with the receivership process, but your receiver is going to have authority that stretches beyond state lines. State court receivers, the receiver authority may be limited, but the judges may be more familiar with the process. But then you have the possibility of being homered, and being homered refers back to the story I told you about. You got your receiver, but you didn't get the person you asked for. You got the judge's buddy, and now you're in a situation where you're like, I should have been careful what I wished for. Nevertheless, receiverships may be a worthwhile alternative to a foreclosure. You really need to work with your counsel to apply the pros and cons to your own particular circumstances. And with that, I think we're almost out of time, so we will take questions at this point. I see we have one question, and Brian, this was directed more towards what you were talking about with the private sale officers. And when you were covering the private sale officers, you were talking about marketing the property, and someone asked, can that private sale officer auction the property, serve as an auctioneer, and sell the property as is, where is?
Yeah, and anytime you're doing a foreclosure sale, it will be done on an as-is basis. So whether you use a PSO, the sheriff, or a receiver, that language will be in there. So you definitely, you'll have that language in there regardless of the method that you're selling the property.
And then do we have any other questions?
I see one question. Here's the question, Carrie. What type of language can you include in the appointment order for a receiver to prevent the receiver from misusing funds and racking up lots of receiver costs and fees?
Oftentimes, what I will see done, particularly when you're going to have a receiver appointed to operate a business, is you put a budget in there. Something similar to what you would see in a bankruptcy case where there's a cash collateral order and there's a budget attached and then there'll be a variance. So what you would put in there is sometimes a budget. And there might be, the receiver can do like a 10% variance by line item or a 10% variance in aggregate cost. Other times you'll see instances where a receiver can do something if it costs less than X number of dollars. Otherwise, he needs to apply to the court for authority, and the other parties need to object. So if the receiver is looking to incur, I see it with capital improvements or maintenance cost, where if a receiver wants to do something that's more than $1,000, $5,000, depending on the property and what's at stake, he has to go into court and ask for authority unless there are really some emergency situations like a hurricane came through and ripped a roof off of a building. So you can control it through a budget or setting limits to what a receiver can do without having to go back and get further court approval and giving the parties an opportunity to object.
All right, it looks like that is all the time that we have today. If you had a question that you did not get to ask, please reach out to Brian or Carrie directly. Please also reach out if you would like to learn more about our commercial workout toolkit or any of our workout capabilities. The next session will be on December 14th, same time, and we'll cover intra and inter-creditor considerations and distress credits. You can register for this session on foreys.com. Thank you for joining us today. This concludes our program. Take care.